Hello friends, today we are going to discuss the case of Commissioner of Income Tax versus SMT Sodra Devi. This case involves the interpretation of section 16(3)(a)(2) of Income Tax Act 1922, which raised the question of whether the income of minor sons can be included in the total income of their mother if she is a partner in a firm. In this case, Rai Bahadur Narsingh Das Daga joint Hindu family was partitioned, resulting in his wife SMT Sodra Devi and their sons receiving a share in the property. The income tax authorities added the income of the minor sons to their mother's total income. The High Court ruled against the decision, leading to an appeal in the Supreme Court. The Supreme Court clarified that the term person in section 16(3)(a)(2) refers only to males and not females. Therefore, the income of minor sons cannot be clubbed with their mother's income. The court also held that when statutory provisions are clear and unambiguous, they should be interpreted in their natural or ordinary sense. Furthermore, a law should be interpreted as a whole rather than in isolated section. The purpose of section 16(3) was to affect the income of males, not females. The Supreme Court upheld the appeal filed by the Commissioner of Income Tax and dismissed SMT Sodra Devi's appeal. The decision established that a mother's income cannot include the income of her minor sons, even if she is a partner in a firm. Now let us study this case in details. Answer: Commissioner of Income Tax, Madhya Pradesh and Bhopal, appellant versus SMT Sodra Devi versus respondent. Reference AIR 1957, Supreme Court 832. सॉरी ये 882 है, गड़बड़ी हो गई है, थोड़ा ठीक कर लें आप लोग. Case summary: This case involves the interpretation of section 16(3)(a)(2) of the Income Tax Act 1922, which includes the term any individual and such individual. Fact of the case: Before October 18, 1944, Rai Bahadur Narsingh Das Daga, his wife SMT Sodra Devi, and their 3 adult and 3 minor sons constituted a joint and undivided Hindu family. On October 18, 1944, the Hindu undivided family was partitioned and the properties were also divided accordingly. As a result of this partition, the ownership of the Hingan Ghat spinning and weaving mills and agency was transferred to the SRC SMT Sodra Devi and her 3 adult and minor sons. This partition was made to ensure the smooth operation of the business. The 3 minor sons of these SRC were entitled to partnership profit and their partnership rights were not disputed. However, the income tax authorities included the income of these 3 minor sons in the total income of the SRC. The Income Tax Tribunal, while interpreting Section 16(3)(a)(2) of the Income Tax Act 1922, concluded that the partnership income received by the 3 minor sons should be included in the total income of the SRC. The SRC filed an application before the tribunal requesting that the matter be referred to the High Court for legal determination. Consequently, the case was referred to the Nagpur High Court. High Court decision: The High Court ruled that the legislature did not intend to include the income of minor children in the total income of their mother. Subsequently, the High Court issued a certificate under Section 66A2 of the Income Tax Act 1922, allowing the Commissioner of Income Tax Madhya Pradesh and Bhopal to file an appeal before the Supreme Court of India for final adjudication on this legal issue. A similar case involved Sri Ishwar Das Sahni, who passed away on November 7, 1946. He was a partner in the firm Messrs. Ishwar Das Sahni and Brothers. After his death, his widow SMT Damayanti Sahni and their two minor sons became his legal heirs. SMT Damayanti Sahni joined the firm as a partner, and her two minor sons were also entitled to a share in the firm's profits. The income tax authorities included the profit share of the minor sons in the total income of the assessees. The interpreted individual under Section 16382 of the Income Tax Act 1922 means any person irrespective of gender. The case was taken to the Income Tax Tribunal, Punjab, where the tribunal held that the term individual applied only to males. The Commissioner of Income Tax, Delhi, then referred the case to the Punjab High Court, Simla. The Punjab High Court ruled that the minor son's share in the firm's income should be included in the assessee's total income. The assessees then obtained a certificate under Section 1666A2 of the Income Tax Act 1922 and filed an appeal before the Supreme Court of India. Supreme Court decision. The Supreme Court heard both appeals together as they involved a common issue. Does the term individual in Section 163A2 include a woman? Question mark. Should the share of profits received by minor sons in a partnership firm be added to the total income of their mother if she is also a partner in the firm? To resolve this issue, the Supreme Court applied the following principle of statutory interpretation. First, holistic interpretation of statutes. An act should be read as a whole rather than in separate sections. Interpretation of ambiguous language. Second, if the language of a statute is unclear, its purpose and subject matter should be considered in determining its meaning. 3. Hidden rule, mischief rule. When interpreting statutes, hidden case principles should be followed to identify the legislative intent. Use of external aids. While interpreting statutory terms refers to other relevant laws and external sources can be made. Literal meaning of words. If the words used in a statute are clear and unambiguous, they should be interpreted in their plain and natural sense. The Supreme Court examined various provisions of the Income Tax Act 1922 and clarified that the term assessees was broad and included individuals, Hindu undivided families, companies, local authorities, firms and associations of persons. However, the term individual was narrower and was not explicitly defined in the Act. The Supreme Court analyzed Section 16(3)(a) and its subsection 1st, 2nd, 3rd and 4th, where subsection 1 and 3 related to the wife and subclass 2nd and 4th related to minor children. All these subclasses use their terms any individual and such individual which the court found ambiguous and unclear. The Supreme Court, referring to precedents, concluded that the term any individual and such individual in section 16(3) referred only to males and not females. Therefore, the minor son's income could not be included in their mother's total income even if she was a partner in the firm. Final judgment. The Supreme Court dismissed Civil Appeal number 322 of 1955 filed by SMT Sodra Devi and allowed Civil Appeal number 2225 of 1955 filed by the Commissioner of Income Tax. This decision was based on a majority ruling delivered by Justice Bhagwati on behalf of himself and Justice Kapoor. However, Justice S.K. Das dissented and gave a contrary opinion. Legal principle established by the Supreme Court. First, if a statute's provisions are clear and unambiguous, the words used should be interpreted in their ordinary and natural sense. A statute should be read as a whole rather than interpreting its provisions in isolation. Third, the term any individual and such individual in section 16(3)(a) of the Income Tax Act 1922 apply only to males not to females. The Supreme Court clarified that the income of minor sons cannot be added to their mother's total income even if she is a partner in the firm. Please share and subscribe my channel. Thank you.